Greetings of the day from the Center of Advanced Studies in Labour Welfare, RGNUL Punjab. A very good morning to Honorable Vice Chancellor RGNUL, Professor Dr. G.S. Bajpai, Worthy Registrar, RGNUL Professor Dr. Anand Pawar, sir, our Chief Guest, Mr. Shailesh Gandhi, sir, former Central Information Commissioner and an RTI activist, and Dr. Varun Chachar, Associate Professor, Lucknow University. Respected faculty members and dear participants, I extend a warm welcome to all the participants in the National Conference on Right to Information, Law, Policy and Governance, organized by the Center for Advanced Studies in Labour Welfare in collaboration with the Punjab State Information Commission. The Punjab government constituted the State Information Commission on 11th October 2005 under Section 15 of the Right to Information Act 2005. The section lays down that the General Superintendent's direction and management of the affairs of the State Information Commission shall vest in the State's Chief Information Commissioner, who shall be assisted by the State Information Commissioner, and may exercise all such powers and do all such acts and things which may be exercised or done by the State Information Commission autonomously. KASLA and Punjab State Information Commission share an old bond, previously having organized 4 national seminars and 1 workshop on RTI. We have also published 2 books bearing ISBN numbers in collaboration with Punjab State Information Commission. You would also be elated to know that in order to contribute towards awareness in the society, KASLA has signed a memorandum of understanding with the Punjab State Information Commission.
Through the years, RTI has undergone several contemporary developments that has led to remarkable changes in the functioning of the scope of the Act. The Act, legitimizing the right to information in 2005, empowered citizens to hold public officials accountable and had far-reaching consequences on the governance of the nation. It ushered in participatory democracy in the true sense by making government departments accountable constantly and not just in the 5 years. Every year, nearly 6 million applications regarding the RTI is filed, making it most extensively used transparency legislation in the world. The RTI Act has also been put to effective use by public-spirited citizens to shine the light on corruption and arbitrary abuse of power by the state. This conference aims to analyze the Right to Information Act from its inception as a grassroots movement to law and its impact on governments, policy making, and the future. I would now like to request Honorable Vice Chancellor, RGNUL, Professor Dr. G.S. Bajpai, to welcome our guests and address the gathering.
Good morning, all. My special greetings to Mr. Shailesh Gandhiji, who is present here as chief guest. Sir, I have had occasion to meet you several times at National Law University, Delhi, when I was working there. And I'm very happy to see you today, gracing this occasion at this workshop based on right to information, law, policy, and governance. Thank you for your presence today. We also have Dr. Varun Chachar from the Faculty of Law, University of Lucknow. Thank you so much for joining this important gathering. And the idea is to have these 2 experts to lead the discussion and to set the tone for the subsequent sessions. Rajiv Gandhi National University of Law has now taken up a task whereby we are focusing on capacity building in respect of public functionaries, people at large, various organizations. And in the series of this kind of activity, we have taken up several initiatives in the field of criminal law, intellectual property, right to information, and consumer protection, environmental protection. And we are now engaging very actively with the public functionaries because I feel that this is a very important task on the part of university to sort of present an audit of the policy and its functioning. With respect to right to information, this university has been engaging itself on a continuous basis for last several years in terms of organizing workshops and organizing activities on the issue of right to information. And rightly so, because uh, for a country like India, the entire, idea of right to information is quite different from other legislations, because the birth of right to information has taken place from a movement. And this movement has led to the introduction of this important empowering tool on the part of citizens. And this is the occasion to really acknowledge the contribution of those pioneering leaders, VP Singh, this is Aruna Rai, and a lot of other people, including Shailesh Gandhiji, who has been actually pressing hard for the introduction of this law. And if you study the entire trajectory of passing this law, you'll realize that the Indian democracy is maturing. I think uh, it can be a very good pointer or a barometer to understand the maturity of democracy in a society if the laws relating to access to information, right to information are at place. That is the hallmark of a democracy. So if I have to gauge whether democracy in this country is functional or not, I'll try to look at the state of affairs with respect to information. It started from Sweden, actually. And then subsequently, several countries who believe in democracy, who believe in making public functionaries accountable as well as transparent, because we have inherited a system from Britishers where secrecy, for good long years, misconception has been, happening that government functioning is to be kept secret. And we were all given to this belief system that anything that government does or a public functionary does, it should be kept secret. And there was the secrecy law also, that you cannot have the information. You cannot have the information relating to the government affairs. Now, moving 360 degree from that position to have right to information as a fundamental right under 19 section, Article 19 of the Constitution, 19(1)(a). So this situation is a very satisfying. I think no other law has this kind of constitutional positioning, as because all other laws are there to promote the objective of the government in some way or the other, primarily. But this law is there to empower the citizens in terms of their access to information. And information is power. The matter doesn't end here. What will happen if you have the information? If you have the information, you can exercise a lot of choices. You can probably decide the course of action. You can probably, take many other decisions. And so having this information or this knowledge with respect to the functioning of the government is very, very crucial in today's. And if you see, there is a test going on between the citizens and the government. Citizens are now demanding information and the state is trying to hide the information. This will continue to happen because the state understands that information is power, power in the hand of citizens. And state invariably doesn't want that power to be slipped from the hands of government to the hands of citizens. And therefore, I feel that since this law came in the year 2005, and there are good 1.5 decades, and this is the time, I don't know, probably you can discuss this issue. This is the time to really carry out a systematic audit or looking into the impact assessment of RTI at this stage, and let there be a white paper. That white paper should be demanded as to how the RTI regime has been functioning during this 1.5 decade. Because, as I am saying, there is a lot of resistance which is being put up in the way of realization of this law. And therefore, it is very important for us to know how the functionaries of RTI regimes are working, what is the satisfaction level of the RTI applicants, and how this entire system is working. We need to know in precise terms this, because this is going to be very, very crucial. As the data was presented, more than 6 lakhs applications are pending. That is the tip of iceberg. I can tell you the insufficient, inadequate answer, vague answer, delay, so many other things keep happening. And this thing actually has to be, checked. And for that, probably we need a white paper. We need a very, systematic audit of the regime of RTI in its functioning for 1.5 decade. And some of these things will, provide us with a lot of ideas and data to further strengthen this entire system of information seeking by the citizen. I'm sure this workshop will provide a lot of, ideas with respect to the RTI issue as such, and also the resource person and all others will contribute to the success of this workshop. I acknowledge the contribution of the team who is working behind this, and led by Dr. Geetika and all other faculty colleagues who have been working very diligently on this activity. I once again welcome Mr. Shailesh Gandhi and Dr. Varun. We are looking forward to their valuable inputs during this workshop. Welcome and thank you once again. Thank you all.
ठंडा किसका ला रही है और स्कूटी से बनाता है
स्कूटी नंबर होगा इस पर पीछे नहीं है
नहीं रहा स्कूटी
Sorry.
Thank you so much, sir, for your kind words. We have with us today Dr. Varun Chachar, sir. Sir is an associate professor at Faculty of Law, University of Lucknow. Sir has over 20 publications in various prestigious journals. Sir has also authored 4 books on RTI with a contribution of over 15 chapters in various reputed books. Sir has also participated, delegated, and felicitated in various national and international conferences across the globe. I would now like to request Dr. Varun Chachar, sir, to address the gathering.
So much. Vice Chancellor, Professor G.S. Vajpayee, sir. Registrar of Rajiv Gandhi National Law University, Professor Anand Pawar, sir. The legend of RTI, Shri Shailesh Gandhi ji, former Honorable Central Information Commissioner and an RTI activist. And I must say that when I was registered for PhD in 2010 in Delhi, you were an inspiration behind that topic, right to information, accountability, and administration of justice. And all the learned professors, faculty members, my dear students. The topic is very quality in a sense, because when we see, these variables, as rightly said by the Honorable Vice Chancellor, sir, that when we talk about public policy and governance, these two initiatives, it is very important to understand that these two initiatives depends on certain important factors. And the foremost factor at this point of time, if we go by the deliberation of the Government of India or by the deliberation of the international conventions, specifically when we deal with good governance, let me tell you this fact that the access to justice mechanism, which directly comes from the freedom of information, is an essence behind this notion of qualitative governance, and it is one of the most important principles of good governance in the whole of the world. There is a reason, as rightly said by the Honorable Vice Chancellor, sir, that when we deliberate upon different kind of understandings throughout the world, and when the legislations are being made, there is a very huge problem, and the problem is secrecy. How the legislations are being made, and ultimately when the legislations are being made, whether those legislations were implemented in true spirit, in true letter and spirit in which they were intended by the legislatures. Now, that is something which is very, very important, and that is why the role of that, Hare Rang ka ek paper aata hai, that's green paper, that is note sheet. That becomes a very relevant kind of a criteria. In my research for almost a decade, more than a decade on RTI, I believe that the more sumo to disclosure we can have by the virtue of Section 4 of the RTI Act, the less RTIs may be filed, as rightly said by the Honorable Vice Chancellor, sir, that there is a pendency of more than 6 lakh applications. Why it is so? We have huge number of pendency at different state information commissions. And I must say that I'm very sorry to say, being a researcher, that even in the Central Information Commission, if you file a second appeal, sometimes it takes 6 months and sometimes it takes more than 1 year. Now, if the situation is such, then it becomes very difficult to, access justice. I believe in my 10 years of research that if you don't have access to justice, there will never be administration of justice. So the most important thing at this point of time is that we will have to have more access. We will have to have more suo motu disclosures. And if we try and understand the spirit of the Right to Information Act, most qualitative aspect behind this legislation is, as rightly said by the Honorable Vice Chancellor Sir also, that all the legislations are in tune with the government, and it is the only legislation which is not in tune with the government. So this is something which is very, very qualitative in a sense. As a student of law, I believe always, if we need to understand the notional aspect of justice, which is embedded within the domain of the Constitution of India, and specifically within the preamble of the Constitution of India, then we must understand that how this qualitative legislation, it is excelling in last 1.5 decade in India. Let me tell you this fact that be it information pertaining to the PMO, be it information pertaining to the Union Public Service Commission, be it information pertaining to the important policies which have been taken by the government, it is always the RTI. All the scams which came into being, which came into the public domain, it is all because of this legislation. I believe this is one of the finest legislation ever in the history of this country. And I must say that it is important at this point of time. We have a legend here. He will talk about all the deliberations. He has given his life for this particular legislation. And I believe that at this point of time, I as a researcher can say that, the legislature, the executive and judiciary, and I must say that with full responsibility, the judiciary also, they are running away from, showing all those deliberations behind those curtains and behind those closed wall rooms for the collegium deliberations. It has been a long history, and I have also submitted my PhD way back in 2015. I have also recommended that the office of the CGI must come under the purview of the RTI Act. And I believe that in my lifetime, this dream will ever become reality. I don't know whether it will become reality or not, but this is something which is very, very important. How come judges decide for themselves? This is a very serious question. And how the decisions have been taken, this is also a very serious question. How the elevations takes place, how appointment takes place, how transfer takes place. There is nothing apparent on the face of record. So now the time has come that it is not only the legislature, it is not only the executive, because there are a number of people who try their best to evade from showing information, but ultimately they will have to, because this legislation is such a beautiful legislation that it compel, it empower a common man to 10 rupees, ask information, and you will be given. What are the deliberations of the minutes of meeting? Nobody knows. At certain point of time, when this legislation was not there, nobody even know how come you can get minutes of meeting, because that is something which is secrecy. That was something which was behind the wall. Nobody know about how the decisions have been taken, but by the virtue of this legislation now, and by only rupees 10, an informed citizenry can ask for information, can seek information, so that the quantum of justice may be achieved within the spirit of the Constitution of India, because I believe constitutionalism is an essence. And if you want to attain constitutionalism, I think this legislation is the need of the hour. Thank you very much. Thank you very much.
Thank you so much, sir, for a valuable insight. The Rajiv Gandhi National University of Law, Punjab, in collaboration with Punjab State Information Commission, conducted the one-day national e-seminar on the topic Changing Paradigm of Right to Information Law, which was held on 15th of March 2021. We are delighted to announce the Center of Advanced Studies in Labor Welfare worked on the book entitled Changing Paradigm of Right to Information Law. It is a collection of handpicked scholarly articles on the developments and laws related to RTI. The main objective of this book is to provide authentic and stimulating material on the theme. This book is a sincere attempt on the part of the team of editors to stimulate intellectual discussions on relatively new aspects of RTI. The editorial team is thankful to the contributing authors and academicians for their immense cooperation. We hereby request the dignitaries to kindly release the book in the offline and the online mode.
Moving further, today, as our chief guest, we have with us Mr. Sailesh Gandhi, sir. Mr. Sailesh Gandhi is a first-generation entrepreneur and a distinguished alumnus awardee of IIT Bombay. He sold his company to become an RTI activist. Sailesh, sir, was a part of the national RTI movement, which was involved in drafting the National Act. I would now like to request Mr. Sailesh Gandhi, sir, to kindly address the gathering.
Fellow citizens of India, am I audible? Am I audible?
Yes, sir.
Okay. Fellow citizens of India, I'm not a lawyer and never went to a law school. But when I was in school, I was taught that democracy is the rule of the people, for the people, by the people. I've often looked around and wondered whether a citizen of India, when he or she interacts with the government, feels as if he or she is the ruler of India. The universal answer is no, it doesn't happen. Then I wonder, how are we a democracy? I believe each citizen in India, not just as a mass, each citizen in India owns the government, owns the country, and is the sovereign of this country. The heart and essence of democracy, my friends, is the concept that each individual citizen is a sovereign in her own right, and she gives a part of the sovereignty to the state in return for which she gets the rule of law. Sovereignty of the individual citizen, respect for the individual citizen is the fundamental. At one such college, when I was giving this talk, a young student got up and said, "Sir, are you serious?" I said, "Yes, I am." He said, "Sir, you said we own the country. I own the country." I said, "Yes, you own the country." He said, "So, supposing I like a government car, can I take it home?" I said, "No, you can't." He said, "But then you are wrong. I don't own the country." I explained to him that yes, you are the owner of the country, but in partnership with 140 crore other Indians. Therefore, if you take the car away, you deprive the other 140 crore citizens. But, and this is important to understand, the information on the files, computers, cupboards of the government, also you own. Each citizen owns it. And if that information is given to you, it does not deprive the others. Therefore, the default mode is, in a democracy, all information belongs to you, the citizen of India. You are the ruler demanding to see some of the information, as is your right. It's a fundamental right as recognized by the Supreme Court of India. But in the last 8-10 years, I think views have changed. What I have realized is everybody in power dislikes being transparent, himself or herself. Everyone likes transparency in others, not in themselves. Incidentally, on legislation being transparent, Section 81I of the RTI Act specifies that when a decision is taken to present a law in Parliament, the reasoning behind it and the cabinet note must be made public. The responsibility is on the government to make it public as per Section 81I. It's an exemption, it's a unique exemption and needs interesting study. Now, unfortunately, as your Vice Chancellor said and previous speaker said, we are now developing a new concept of sealed cover jurisprudence, where we are going away from transparency into opaqueness. If you look at the collegium decisions 4 years back on the Supreme Court's website, you find reasons given for selecting somebody or suggesting a name for judgment, for judgeship. After that, it stopped. Now all you see is a list of names, no other reasons, no other reasoning. And I think this is something we need to be careful about. We are sliding back. We have one of the best laws in the world. I am proud to say that, but I think we are slowly regressing, and this is something we need to be very vigilant about. Democracy and liberty are things that citizens need to be vigilant about. If citizens are not vigilant, they will lose their rights, they will lose their democracy. Now, most of us know about what good has happened on RTI, and this has been spoken of before. But I'd like to raise some red signals about the danger signs that RTI faces, and unless citizens wake up and defend their right, their liberty, they will lose these rights slowly, and this is what I'm going to describe. In 2011, for the first time, the Supreme Court gave a ruling in Aditya Bandyopadhyay versus Aditya Bandyopadhyay versus CBSE, in which it said, and I quote, indiscriminate and impractical demands or directions under RTI Act for disclosure of all and sundry information and accountability in the functioning of public authorities and eradication of corruption would be counterproductive, as it will adversely affect the efficiency and administration and result in the executive getting bogged down with the non-productive work of collecting and furnishing information. The Act should not be allowed to be misused or abused or become a tool to obstruct the national development and integration or to destroy the peace, tranquility, and harmony amongst its citizens. Statement made without any evidence, without any proof, not related to the matter in hand at all. This was just an outpouring of their anger at having to be transparent, at having to share information with the lowly citizen of India who was the ruler of India. This is being missed. And after this, various bodies, public information officer, public authorities, and some commissions have taken the unprecedented step of banning citizens from using the right to information. This would be like saying you are banning a citizen from using his fundamental right. And I think even the Supreme Court should be wary about trying something like this. For information commissions or public authorities, this is patently illegal. I repeat, it is patently illegal to ban or to call people blackmailers and misusers of RTI. They are using their right under the Constitution. Just as I can speak what I like, unless I transcend some laws, unless I violate certain laws, that is my fundamental right. Right to information, right to publish, and right to speech are all equivalent under Article 19(1)(a). Now, one gross misinterpretation of the law that is occurring very widely, and which I'd like to draw your attention to, it has the potential of finishing off the RTI Act and converting it into a right to denial of information. The RTI Act of India is perhaps one of the few RTIs in the world in which we have put down in the preamble that curbing corruption is one of the objectives of RTI. And that is true. You cannot have better monitors of the governance and government than the citizens of India. Incidentally, I'd like to briefly touch on how we have tried to fight corruption. Most Western democracies do not have vigilance departments in government departments. We have vigilance departments in most government departments. That doesn't work. So we have an anti-corruption bureau. That is ineffective. Therefore, we have a Central Bureau of Investigation. We are not satisfied with the output of that. Therefore, we have a Central Vigilance Commission. Not satisfactory. Now we have a Lokpal who sits in Delhi and does nothing. Have any of you heard about anything being done by the Lokpal? They burn a hole of about 3 to 5 crore rupees a month in the treasury and deliver virtually nothing. Your best bets for curbing corruption and for getting better governance is the citizens of India. And they are empowered by the Right to Information Act. One of the best acts in the world, and I'll point out a few things in which wrongly information is being denied. Section 7.1 says rejection of a request can only be due to reasons specified in sections 8 and 9. People have started saying this is sensitive, this is confidential, all of which is not as per the law. It is illegal, unconstitutional. 8.1J of the exemptions has been grossly misused, and I'd like to spend a little time explaining this to all of you because I'm sure you can fight this. 8.1J of the law exempts information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual. Unless the PIO is satisfied that the larger public interest justifies the disclosure of such information. Provided that the information which cannot be denied to Parliament or a state legislature shall not be denied to any person. As you'll carefully note, this does not exempt all personal information. Personal information is a class may qualify for this, provided it has nothing to do with a public activity, provided it is not an intrusion on privacy, and provided information could be denied to Parliament or state legislature. This is the acid test given to it. It was understood when framing the law that it would be difficult for a public information officer to figure out what is a public activity, what's a private activity. My submission is everything on public records is the consequence of a public activity. What happens and does not go into public records is not a public activity and therefore is not the subject matter of right to information. With this, the other thing is whether it is intrusion on privacy. Now, in Puttaswamy judgment, privacy has become a big issue. You read the 570-page judgment, they go into theories, philosophies of what is privacy, etc. A man should be left alone, then he should go to the Himalayas, in my opinion. But it does not tell you what privacy is. It says it will develop on a case-to-case basis. Is it expected that every PIO faced with a RTI query should go to the Supreme Court? This would be an unlikely situation. Therefore, the lawmakers put down a proviso. They were aware of this conundrum. They said, provided information that shall not be denied to Parliament or state legislature shall not be denied to any person. What is the meaning of this and how can it be interpreted? And that's the only way it can be interpreted. Whoever denies information under claiming exemption under 8.1J must make a statement that, in my opinion, I would not give this information to Parliament or state legislature. That's the only way the law can operate. Incidentally, Article 19.2 covers under which circumstances my rights under 19.1A can be violated or curbed. And there are only two words relating to privacy: decency or morality. If release of any information violates decency or morality, it should not be given to Parliament, it should not be given to a citizen also. Apart from that, all of the information, if it is violation of privacy, it should not be generally collected by government. Everything on public record should be available under the Right to Information Act. Unfortunately, grossly, the Supreme Court itself has ruled in Girish Deshpande that all personal information can be exempted. This is not as per the law, not as per the Constitution of India. It neither fits with the Constitution nor with the law. The lawmakers specifically put this proviso: provided information that shall not be denied to Parliament or state legislature shall not be denied to any person. This test is not being applied by commissions, by PIOs, and by courts, including the Supreme Court of India, which is very, very sad. There is no discussion on this, there's no debate on this, and I would invite students from your university to at least debate the point. I'm not saying if the Supreme Court has said we have to abide by it. The Supreme Court has given no reasoning as to how it fits in the Section 8.1J. I would invite students and faculty to think about it. When our fundamental rights are diluted without our concurrence, citizens need to be vigilant. citizens need to defend, at least discuss with an open mind, is this in consonance with the law? There is one disturbing piece of news that I read this morning, unfortunately, which says the data protection bill that is coming now is proposing an amendment to Section 8(1)(j) of the RTI Act, where all these words that I'm talking of will be removed. This has been proposed and this must be opposed all over the country. Previous amendments to the RTI Act have been opposed by citizens, rightly so. This is the most damaging amendment to the law, and if it goes through, I think the right to information will become a right to denial of information. I'm sure the citizens of this country will defend their fundamental rights. Some people say, if the government proposes something, what can we do? To this, my simple answer is, this is a nation that threw a foreign rule out of this country in 1947. The citizens of India did it with a foreign ruler. This is our own government. This is our own judicial system. Can we not persuade it and defend our fundamental rights? Yes, the Supreme Court is supposed to defend our fundamental rights, but in this case, I'm very sad to say the fundamental rights are being affected wrongly. And if all personal information can be barred, no information relating to corruption will be exposed. Because anything that relates to a natural person can be termed personal and can be denied. Even now, de facto, they are doing it without the sanction of law. Now, with the data protection bill amendment suggested, if it goes through, it means our fundamental right will be affected and we'll have no recourse to get information. Please understand, liberty is something that needs to be defended. If you do not defend liberty, you lose liberty. You lose democracy. We are today called a democracy because we have a fair system of elections by which we are able to select our government leaders, governments, and so on. I would submit that and the constitution does not make a democracy. Democracy is when each citizen's right is defended. And we and you, my young friends, need to defend this right. I'm thankful to all of you for this patient hearing that you've given me. And I'm sure we will all move towards a better democracy, a democracy where citizens' rights are respected, a democracy where the poorest and the weakest get the opportunity to defend themselves. Thank you very much. Thank you. And in case there are any questions, I'd be delighted to answer them. Dhanyavad.
Thank you so much, sir. I would now like to request worthy Registrar RG Annual, Professor Dr. Anand Pawar, to felicitate Dr. Varun Chachar, sir. Thank you, sir. I would now like to request Professor Dr. Anand Pawar to propose a vote of thanks and bring this inaugural ceremony to an end.
Thank you. Good morning, one and all. I feel privileged to propose the vote of thanks to all the individuals, those who have contributed to make this National Conference on Right to Information Policy and Governance, organized in collaboration with the Right to Information Commission Punjab. In general, to all the individuals for making their efforts, and specifically to our the chief guest of the inaugural session, Dr. Shailesh Gandhi, which I met first time when I was the officiating Vice Chancellor at RGNUL. And while sitting there as a Chief Information Commissioner, he visited. And at that point of time, he said that this legislation is going to create a great impact and to empower the citizen. And now, today, he is saying that he has already empowered and shifted the power and made the individuals as sovereign rather than the government being the sovereign. So the goals with which the constitutional preamble are set for empowering the individuals is up to an extent achieved by this legislation, and for which all the efforts made by the people like Shailesh Gandhi, we all should be thankful to them. So on behalf of the university, I am thankful to you, sir, for sparing your valuable time and insights on this inaugural session. Our other guest, Mr. Varun Chachar, who has made it possible all the way. He came within a very short notice. He has agreed to deliver a special address to the inaugural session on behalf of the university. I'm thankful to it. And behind this, organizing this conference, the Vice Chancellor has always supported us. So for creating such sources where the individuals can make the effort to discuss academically on these, providing this platform to discuss on various aspects of law. I'm thankful to the worthy Vice Chancellor. And I'm also thankful to the Right to Information Commission Chairperson of the Punjab, who have not only provided, collaborated with us, but otherwise also they have provided funds to conduct various kind of researches in the area of Right to Information Act. And we are also designing a course on Right to Information Act to make the people aware, because somewhere still that the kind of fear which is there in the mind of the government officials or the administrators, they need to be educated that how to keep the record, how to prepare the information, what kind of information are required to be provided. If the training part would be strengthened, then much of the problems can be reduced. So on that part, the university is also working, for which our faculty members, Dr. Geetika, Dr. Shruti, Dr. Rachna, they all are doing in that behalf. And we will contribute also in this part on the university behalf. I'm also thankful to the Center for Advanced Studies in Labor Welfare, RGNL. They have prepared a booklet also, which may help the individuals to know about the basic information about right to information, its filing of complaint and appeal process. I request the center to circulate it more and to send it to the common people also, so that it helps the educating it, the people regarding these aspects. I'm also thankful to all the administrative staff of the university who have helped us to organize this event. And last but not the least, the student volunteers who have worked day and night to make this event a successful one. I request to give a big round of applause to all the students who have made it possible. So thank you one and all for being with us. Thank you.
Thank you so much, sir. That brings this inaugural ceremony to an end. I would request all the participants and resource persons joining us online to kindly wait while we assign you to your respective breakout sessions. Participants joining us offline are requested to move to their assigned rooms for paper presentation. Thank you.
अभी मेरा जो है ना